Welcome to Washington in Focus Daily. It is Friday, June 26th, 2026. I'm Colleen Johnson, the Center Square, Washington's state government reporter. And in today's episode, tomorrow, the 27th of June, marks 8 years since the landmark U.S. Supreme Court Janus ruling. And this was the ruling that gave workers' rights, basically, and the ability for union employees, public employees, to opt out of paying union dues. We're going to wade into that a little bit with Elizabeth New of Washington Policy Center. And Supreme Court Justice Colleen Medley, appointed this year by Governor Ferguson, still has to run to maintain that seat. She will be on the ballot for the August primary, and assuming she moves on, facing an opponent for the November election. My colleague Tim Clauser chatted with her about whether she plans to recuse herself, assuming that a fight over the income tax reaches the state's high court bench. So that exclusive interview coming up in today's episode. And then finally, a huge win 23 years after a court challenge was filed against the Washington Department of Retirement Systems for skimming off the top of the pension fund for teacher pensions. Finally, a ruling from Thurston County Superior Court this week, literally 23 years later, that went in favor of the teachers who got ripped off by the state of Washington. So let's dive into today's episode. Saturday, the 27th of June, marks 8 years since the landmark Janus decision, where the U.S. Supreme Court ruled that public employees have a right to join or not join their union. Now, since then, millions of public employees have opted out of paying union dues. But according to Washington Policy Center's Elizabeth New, who heads up their Center for Healthcare and Worker Rights, many employees still are unaware that they even have the right to opt out.
Yeah, the 2018 Janus decision was a game changer. It means that union membership is entirely voluntary. You can be a union member and pay it dues, and a lot of people enjoy doing that. You can not be a member and not pay dues or agency fees, as used to be the case. So you can choose either way, and that's really helpful for people, especially with ideological reasons, to be against union membership. A lot of people see the union politicking in ways that don't align with them. And so seeing their money go to political purposes that they don't agree with is what this whole case was about. Should they be forced to finance a union speech that they disagree with? So the Janus decision declared a First Amendment right for these people. They can join or not join a union as they wish. Since then, it's been 8 years. A lot of workers still don't know about this right. It isn't included on required workplace posters about a worker's rights. It's not listed on a state website where other rights are listed. So if union membership is truly voluntary and we care about all workers' rights, employees should receive neutral information about membership before a union gives them paperwork to sign up, because then they're often locked in for a while. So what we're hoping to do, WPC created a resource that public employers could download and give to their workers upon hiring in onboarding materials, or they could post it as a poster in a staff lounge next to other worker rights that are required by the state. So our point is to just make this about worker awareness. It's plain and simple. You can join a union, you can decline membership. It's up to you.
Washington Policy Center created a one-page resource that employers can simply download and give to their workers as part of their onboarding materials. You're a new employee. You're going to have the pitch from the union as to why you need to opt in and how good it is for you and all the benefits. At the same time, maybe you should have some information about why you might want to opt out. But as New with WPC told me, they really are hoping that this 8th anniversary is an opportunity for the public employer, not the employee, but the employer, to see the benefit of really educating their employees, especially those new enrollees, as to what their rights are. Now, Olympia-based Freedom Foundation created an opt-out site right after the Janus ruling to assist public workers in exiting their unions. And they reported they are on track for another record year as of May this year. They have helped, get this, more than 275,000 public employees exit their union due obligations. And to date, that has cost public sector unions an estimated $791 million in revenue, according to Freedom Foundation, as of a May 21st published article. And I spoke with Freedom Foundation CEO Aaron Withy back in December of 2025. At that point, for the year, just for 2025, they helped more than 50,000 employees opt out of their unions, and 5,000 of those workers were right here in the state of Washington.
We have to expose what the unions are doing because no one else is going to tell them. The unions aren't going to tell them what they're spending their money on. The state certainly isn't going to tell them what they're spending their money on. So the Freedom Foundation has to expose what the unions are doing. Take the National Education Association and the American Federation of Teachers, for example, the country's largest two government unions in America, teachers' unions in America. They spend around 10% of their budgets on, quote, representational activities, meaning this is what we deliver to teachers. The rest of their money is primarily spent on gifts to politics or to left-leaning nonprofits, C3s and C4s, and then, of course, staff overhead, salaries and benefits for them. So their primary jobs are not representing teachers, otherwise that's where they'd spend their money. They see their primary role as political advocacy. So that's what we expose to teachers and other public employees every single day, is that your $80, $90 a month is being spent on stuff that doesn't go towards your benefit. So our message is simple. Opt out, put that money back in your pockets, and just try it. If you do it for 3 months and you really feel like you missed the union, they're not going to prevent you from rejoining. But most of the time, people do not rejoin those unions. They find that money better off in their pockets.
Now, because unions across the country have lost out on hundreds of millions of dollars when these public employees exit their unions, they're in no hurry to make sure you know you have the right to opt out. I totally get that. And as a consequence, several states, blue states, have passed laws to require public employers to make sure that the unions have access to those employees at their orientation when they're doing their onboarding. The unions can sit there and say, hey, wait a minute, make sure you sign up right away. Otherwise, you're going to miss out on thus and such benefit. But the Freedom Foundation and other groups have filed litigation, and they've lost repeatedly, to say, okay, wait a minute, if the unions get a chance to, have access to these employees at onboarding, why can't we also have access to make sure they are aware of their rights to opt out? Another tactic that's been used by union leadership in recent years has been to limit the opt-out window for employees so that if they miss that annual opportunity, they're obligated to keep paying those union dues for another year until the next opt-out window opens up. And New at WPC told me that lawmakers even this year passed legislation that is providing some funding for public employers to notify workers about their rights. Things like overtime rules, and maybe, there's a poster in the staff lounge that says, make sure you're aware of what the Paid Family Medical Leave Act, affords to you. But at the same time, they're not using that funding to make sure that workers are notified of their rights to opt out of paying union dues.
Worker rights they're interested in get added to posters, and the other ones, like Janus rights, get fine print. And I can only guess that's because of the union influence over this issue. Unions right now have access to employees after hiring that other groups do not and will not and should not. It's a third party. And our state also takes dues collections for unions. It facilitates that with government payroll systems. So the issue is really muddy. I mean, if you were just hired as a new worker, you don't follow news in 2018, you just might not know that this isn't a workplace requirement. You're being given these papers in a new hire orientation from a union. It's muddy.
So again, many of these unions again have created these narrow opt-out windows. So you have to really educate yourself. And that's why groups like Washington Policy Center and Freedom Foundation have gone out of their way to run these education campaigns. If you check out either of their websites for WPC or Freedom Foundation, there's a lot of information there. And they even go through each of the different state unions here in Washington state. And so you can just click on that box, say you're a member, AFL-CIO or WFSE or WEA, if you're an educator, you can click on those and go directly to information about how to opt out of that specific union. Because again, the rules are different based on your union representation. All right, now to our second item for today's episode of Washington in Focus Daily. The Washington Supreme Court races are getting a lot of attention this year, and we've been paying a great deal of attention to them in our daily podcast. And that's because there are more open positions than ever, 5 of the 9 races on the ballot this year. And of course, we have the potential income tax challenge out there that will likely eventually make its way to the state's high court. Now, Justice Colleen Medley was appointed earlier this year by Governor Bob Ferguson. So she is one of the new justices on court this year. Justice Theo Angelis is the other one. Colleen Medley, previously worked in the office of the Attorney General, while now Governor Bob Ferguson served as AG. And then Ferguson appointed Medley about a month before, publicly calling on lawmakers, the governor, to pass the income tax. Now, the appointee, Colleen Medley, has also donated to Bob Ferguson's campaign and also to AG Nick Brown's campaign. Nothing illegal about that. It's important to point out. But critics have been arguing that those ties could raise, recusal questions if the income tax case does reach the high court. So my colleague Tim Clouser pressed Colleen Medley in an exclusive interview about that very question and whether or not she thinks she should step aside from a future income tax case.
Given those relationships, the donations, and the AGO's role in defending the state's tax position, do you think that your impartiality could be reasonably questioned if the income tax case comes to the bench? And if so, would you or would you not recuse yourself?
So that case is not here, and I don't prejudge any request for recusal that might come when it comes. As I understand from media reporting, that may be going on the ballot. And so if anything, that case is months or years away. And so I'm not going to prejudge any recusal request because that would be inappropriate. The whole point is that, we wait for the cases on the facts and the law as they come. And I imagine, although I don't know, but I imagine that, one of my opponents who is a experienced tax lawyer would say the same thing, right? I don't think that he would think that he was unable to comply with his oath of office. And on the tax, I'm not sure how it cuts for me. Retired Justice Phil Talmadge, who is one of the lawyers working on that case, as I understand it, has endorsed me. So I don't know if that means, on this view that I have to recuse myself. This argument just doesn't have a beginning or an end to it, really, in a society where First Amendment rights allow people to endorse candidates, to oppose candidates, right? It's not clear to me where this begins or ends. If the idea is that anytime we're supported by somebody, then that means we can't separate our own judgment from theirs.
So some of these 5 Supreme Court races have more than a handful of candidates vying for those positions. Voters have a chance to weigh in at the August 4th primary, and each of those fields will be narrowed down to 2. We have a top 2 primary in the state of Washington. Of course, those Supreme Court races are considered nonpartisan, though you can sort of tell where political leanings are for those candidates by just looking at public disclosure campaign donations for them. But again, after the August 4th primary, we'll have those fields narrowed down to the top 2 vote getters for each of those positions. They will then advance on to the November general election ballot. Okay, moving on. Thurston County Superior Court this week entered a final order. In fact, it was just yesterday on Thursday, a final order in a long-running class action lawsuit against the Washington State Department of Retirement Systems, DRS. This order requires DRS to return $120 million of skimmed interest money and investment returns into the retirement accounts of 26,000 public school teachers in the state of Washington through the TERS Plan 3, the TRS Plan 3. This case goes back, I kid you not, to 2003. So I spoke this morning with attorney Steve Strong. He has been on this case since day one. Yes, 23 years ago. It's hard to believe that a case could take 23 years to play out. And the state has been fighting this and delaying all along the way. At one point, he explained to me spending 5 years rewriting some rules. So finally, again, this week, this Thurston County Superior Court judge agreed with the plaintiffs that the state had no right to skim the interest of that fund for teacher pensions.
Well, the Department of Retirement Systems was promised the people in Plan 2 5.5% interest calculated annually and compounded quarterly, and it did not provide that amount of interest. It withheld part of that interest by calculating it incorrectly. So then when the people transferred to Plan 3, most teachers did actually, they did not receive all the interest they were promised. And we brought this case in order to recover that interest. And the money has been held by the state all that time since then. So it's been invested by the state and earned a lot of money. So the amount of money that was originally withheld was $12 or $13 million. But the interest on that, over compound interest for many years, has built up the amount to be a large amount. It was always done secretly until our first client discovered it. And then once it was discovered, the state just maintained that they had discretion to do it any way they wanted. And the promise didn't mean anything.
Now, the original ruling from the Federal Ninth Circuit Court of Appeals in favor of the plaintiffs was made back in 2018, saying again that the Department of Retirement Systems had in fact skimmed earned interest off of the teachers' retirement accounts going back to 1996 and kept all those earnings and withheld the interest, and the state then made profit off of the interest that they had skimmed off of the pension fund. It kind of seems like it should be illegal. And a Thurston County judge again this week agreed with the plaintiffs. It's to the tune again of about $120 million. But again, this is important. This case has been churning for 23 years, originally filed in 2003. So I asked the attorney, Steve Strong, in our conversation just this morning, who again, I thought this was interesting. His son was in middle school when he filed this. His son has now been with the law firm for 10 years, if that gives you any concept of how long this thing has dragged on. What is the status of all these teachers? Many of them since retired, some having passed on, since again their pensions were pilfered by the state.
Received information from the department a few days ago saying that 61% of the people in this class have already retired. So they need that money, have needed that money. 7% are actually dead. They've already died since the case took so long. And another 20% or so like that have been lost and need to be found. So there's because of the delay, there's been a lot of problems for our clients. And the state is going to have to do a lot of work to find those people and give them the money they deserve.
I did reach out to the Department of Retirement Systems this morning, as the attorney again told me they've already said they're going to appeal. So will that in fact hold this up even longer? DRS did not respond to my emailed request sent twice today. So that is it for today's episode of Washington in Focus Daily for this Friday, the 26th of June. I hope you get out to enjoy a lovely weekend. The weather's turned a bit, but it's not all bad. And I know my plants need it outside. I'm sure yours too as well. So again, enjoy the weekend. We hope to see you again on Monday.